Good morning, everybody. Can you hear me now?
I hear you, yes.
Not
Morning.
to
Yes,
be
Your
like a
Honor.
Verizon commercial, but
Hmm.
right. Well, thank the parties for your cooperation. We had another Zoom OA run over, so that's why we had to start y'all a little bit later. In the meantime, welcome to a session of virtual oral argument from the 5th DCA. I'm Judge Edwards. I'll be presiding. Along with me are Judge Harris and Judge Soud. We have one case on our Zoom docket now, and that's case 23-2068, James Powell versus State of Florida. You'll see a timer in one of your boxes there that shows 20 minutes. Each side has 20 minutes. That's your full time. When you're into your rebuttal time for the appellant, the yellow light will illuminate. Since it's not always easy to see, if I see that you're kind of ignoring the rebuttal time, I may give you a little jab so that you'll know it's there. And when you get to the red light, the end of your 20 minutes, that's it. You need to stop. And that goes for both sides. So please turn any noisemakers you have on silent or vibrate. Don't turn them all the way off in case we lose you. That's how we get you back. With that then, Mr. Foreman, we will start with you.
Thank you, and good morning. May it please the court. Jason Foreman on behalf of James Powell, the appellant. I would like to reserve 5 minutes for rebuttal, please. As the court knows, this case has some very interesting issues, perhaps even one or two of first impression, but the facts are relatively simple. The appellant, 15-year-old James Powell, and his friends went to the Tatros resident, who was the listed victim, to attend a party. They thought it was going to be a party, but it was really a small gathering. There was some debate about whether Powell and his friends were initially invited by one of the attendees, Jordan, which it later was determined they were. But once they arrived, a dispute arose between Powell and the residents, the father, the son Wyatt, and a friend Dylan. Now, the record shows that Powell was told to leave, and the fact that he was told to leave is actually a critical matter in this case due to the armed trespass issue. Now, in fact, the trial is saturated with testimony that the defendant was told to leave the property. The state's 4 witnesses and its rebuttal witnesses testified to this, and at least two of the defense witnesses testified that Powell was told to leave. And of course, in closing argument, the state argued that he was told to leave, and defense counsel acknowledged it as well. And this case is no different as far as, two theories or versions of events. The state's theory was that the appellant was the aggressor who pushed the Tatro first, and then Tatro shoved him back. The appellant brandished a firearm, pointed at the victim grabbed the firearm, it was discharged, shot him in the neck, and then his son Wyatt supposedly army crawled, received a shotgun, and then fired it. And of course, according to the defense witnesses, Mr. Tatro came out of the party furious. He pushed the defendant into the car, which caused the appellant to take out a gun, which again discharged when Tatro grabbed it. And then, according to the defense theory, the shotgun was already out at that time when the gun was brandished. Now, unfortunately, Mr. Tatro, the father, became a quadriplegic, and he had certainly a host of medical issues. And as the court knows, 3 years later, he unfortunately catches the COVID virus, dies, and the appellant's charges are upgraded from aggravated battery to first-degree murder. Now, obviously, I raised several issues in my brief, and I want to first just kind of go in the hierarchy of the order regarding the erroneous giving of the forcible felony instruction. And of course, the state does not dispute that the instruction was improperly given, but instead they argued that it did not rise to the level of fundamental error because the defense was not the primary defense and the defense was weak. And of course, perhaps the most egregious part of this is, and I think standing alone warrants a new trial, is when the court included the non-forcible felony offense of armed trespass in this forcible felony instruction, which was not a forcible felony. Now, I think what's telling too is in my initial brief, I made a big to-do about extremely weak versus weak defense. The state never claims that the defense was extremely weak, just merely categorizes it as weak. And of course, the facts of this case, depends on who you believe, does not result in a finding, and I don't think anyone could conclude it was extremely weak. Perhaps it wasn't as strong as some other ones, which under the Daniels case cited in my reply brief on page 4, recognizes that even if it's not particularly strong, does not equate to extremely weak. So,
Counsel, tell me what the difference is between weak and extremely weak.
that's a very good point, but obviously there is a distinction because all the case law talks about extremely weak. Extremely weak would be actually the Barron case that was cited by the state, where these guys went to beat up some people. They pulled out, they had AK-47s, they had tactical gear, they're standing over them. The victim, he said it was accidentally shot him. That's an extremely weak self-defense. This is a claim where there was disputed testimony that my client, and all the evidence suggests that he took out the gun depending on who pushed who first. So that's the question. So is it an extremely weak case? Absolutely not. Is it a weak case? I don't even think it's that.
Explain the self-defense part of it to me, because your client, upon being pushed, whether it was the first push or the second push, said you don't know who you're messing with a added F-bomb dropped in there, and then said, I'm going to effing kill you. And that's not, please leave me alone, don't hurt me, let me go, I just want to leave. It's, you push me, so I'm going to kill you. How is that self-defense?
Okay, that's a good point, but that's if you believe the state's witnesses. The defense witnesses have a different version of that. So,
well, in whose light do we take the testimony when we're looking at the defense, and whether it was extremely weak, strong, whatever? How do we judge that? Who do we listen to?
I think it's an objective standard. I don't think that it's not like a judgment of acquittal in light most favorable to the state. It's certainly an objective standard. So you have competing witnesses, and the fact of the matter is he did pull the firearm after there was a scuffle. Now, that could constitute non-deadly force, so it's not an absurd or extremely weak self-defense, because
But then he racked the slide to arm the firearm and must have had his finger on the trigger, or most likely did. This is not pulling a gun out and waving it around, I got a gun, leave me alone. This is, I'm going to kill you.
Again, it depends on who the jury believes.
Who testified that he did not say that?
One of the witnesses, and the state's witnesses, said that they didn't recall if they racked it. One did, but the defense witnesses don't say that he racked a gun and said that he threatened to kill him.
Did they say he did not, or did they not see it?
I don't recall. I don't think they disputed that he did it. They said he pulled it from his waistband. That's what they said. Or they just didn't see it. They just saw the gun out.
And that's fine. I don't have a problem with people not seeing everything or not hearing everything, but I don't know of anybody who says they heard everything and he did not say, I'm going to kill you.
There was a dispute as to what was said. Yes, the state witnesses were 100% in line with that. But even the defendant's son, the victim's son, Wyatt, didn't even say that the gun was put to his head. The prosecutor had to nudge him and say, well, some people say that it was touching his head. And he said, oh yeah, it was touching his head. So even
it was pointing at him and they were within arm's length, I thought he said.
That is very true. But again, pulling a firearm is not deadly force as a matter of law. So if he reasonably believed that he was under the non-deadly force standard, that he was in fear of imminent harm, then he could pull out that firearm. And of course, it's up to the jury to believe what's deadly force or non-deadly force. But it's still available to argue non-deadly force, and that's what was done in this case. But in addition to that, the armed trespass inclusion in the forcible felony instruction is very problematic for the state. The armed trespass occurred when he arrived on the property, he was told to leave, and he possessed a firearm. So basically, under this argument, under this inclusion of this non-forcible felony, once that occurred, he could not have acted in self-defense. So that in and of itself is fundamental error, because it negated his entire claim of self-defense when it's not even a forcible felony. And that's what those cases talk about, the Montgomery and then the other case I cited for the same principle with the
Counsel
cocaine.
Martinez and some of the other cases talk about basically three factors. Was this his only defense? Was it a strong defense? And did the prosecutor mention it in closing, correct? I mean, that's kind of like
That's
the
true.
three things you look at.
Yes, sir.
And here he had three defenses: self-defense, accidental discharge, and COVID as the cause of death, correct?
Well, I wouldn't say causation was a defense because they never got, the jury was never received an instruction. It was just an element. So that's not an actual affirmative defense. So it's really just attacking the element.
Strategies, and sometimes the cases talk about strategies. Certainly, the defense argued as a strategy that when he was shot, he lived 3 years just fine. He ultimately succumbed to COVID, correct?
That's true.
Okay. So
But
this is not the sole defense.
Correct, but the accident doesn't come into play unless the jury believes he acted in self-defense. Because once he brandished that firearm and pointed it at Mr. Tatro, only then can he claim accidental discharge. Because if there's no self-defense, he committed an aggravated assault. So first, the primary hurdle that must be cleared is a demonstration that he acted in self-defense. And even if it was non-deadly force, it was elevated. I mean, you know, the struggle with the gun occurred, which made it an accident. So the primary defense has to be self-defense. Otherwise, he's admitting to being guilty of aggravated assault. So that's why this case is different than other cases where, you know, you may have a dual kind of argument. You know, it has to go in that particular order: self-defense and then an accidental discharge. Otherwise, he's guilty of aggravated assault. Now, as far as argument 2, which deals with the judgment of acquittal regarding COVID as an independent intervening act, you know, I recognize the standard of proof. I mean, the standard looking at the evidence most light favorable to the state. I recognize that Mr. Tatro's health was greatly diminished, but the release of this COVID virus, and I don't want to sound like a conspiracy nut or whatever, but I mean, look how this came about, and I think it's important. You know, a virus is leaked from an experimental lab in China. It spreads all over the world, shuts the entire world down. The victim catches it after he's paralyzed, dies, and then the defendant's charged with murder. I mean, it sounds so far-fetched. It's almost like being struck by lightning, but you died because you had some other health conditions. I mean, I would respectfully submit that even in the light most favorable to the state, and even with the doctor's testimony, that this is an independent intervening act that was so rare that it has to be found to be the sole cause. And I believe that the court should have granted a judgment of acquittal based on that ground. And that's what was raised, although not 100% perfectly.
So again, self-defense was certainly not the only defense strategy.
Strategy, no. Correct. But, you know, I mean, but that was his primary defense. His primary strategy was self-defense. Now, as far as issue 3, I'm going to jump to that. I see I have about 8 minutes left. The indictment, and of course, that we set forth in the motion, in our brief rather, was fundamentally defective because they didn't allege the date of the death. They alleged the date of the shooting, and in the indictment for that ground 1 had commingled charges of attempted murder and the completed act of murder. So again, as argued in my brief, this was not just a Scrivener's error. This was something that's so fundamental. He was convicted of an offense based on a possible date. And of course, I'm aware of, you know, the state's argument and even the case law that I cited. But if we looked at his death certificate, it doesn't show 2019, the date of the act. It shows 2022.
Counsel, how would the case have been defended differently or prepared differently on the part of the defendant? What's the prejudice to the defendant?
There's no prejudice in the preparation, and I understand why the court's asking that because that's what the case law says. But the prejudice is being convicted on a fundamentally void indictment because there's no continuation language. There's no language that says he was shot in this date and then languished until 2022 upon his death. it just doesn't make any sense that he's convicted of murder on a date 3 years prior to that. And I know that a date has been held not to be a substantive part of the indictment, but in this particular case, in conjunction with the defective commingling of offenses, then I respectfully submit that the charging document was void and his conviction therefore must be void. So if the court doesn't have any other questions, I'll rest on my arguments, on my brief on the other arguments. I'll reserve the rest of my time for rebuttal.
I don't see any questions being raised, so thank you. We'll go on then to the appellate, to the state. All right, you may proceed.
Thank you, Your Honor. May it please the court, my name is Richard Palace. I represent the state. To work backwards real quick, I believe we only got to 3 of these points. Just to quickly address the fundamental errors that would be associated with that charging information. As this honor mentioned, there's no prejudice here. Typically, when an information or an indictment has issues, it's voidable. It's not going to be void. And in this particular case, we can't find any prejudice with the date because, of course, this indictment comes out in March 29th of, I believe, 2022 or 2021. 2 months later, the discovery of the actual medical examiner's opinion, as well as her report, is all divulged to the defendant in May. There's no question of when these dates were. The date that's charged in the indictment is the date that the defendant took his action. And we're charging the defendant here for shooting the victim, and then, of course, the victim ultimately passing, unfortunately, due to complications that are related to this shooting that was done to him and rendered him quadriplegic, as testified extensively by the medical examiner, Dr. Boggs here. And in terms of the commingling of these charges, attempt is charged as a lesser plenty of times in these cases. From what I've seen with countless older DCA opinions, and important here is the fact that in the event that language arguing attempt is not part of an information, sometimes it's actually a problem and prejudicial to the defense because they weren't certain that they were facing attempt until the trial comes. And that's usually when reversal would happen. To move on into just the causation, it's in the light most favorable to the state. Certainly the pandemic was hard on everyone, but catching the coronavirus, no different from catching the flu, catching RSV. I mean, catching the common cold. This man was rendered quadriplegic from being shot in the neck by the defendant here. There was extensive talk of him having trouble breathing. If what has been done to me is harming the way that I'm able to breathe, any disease I catch that's going to hamper this, even strep throat or which not, I imagine would be a problem. Certainly he was trying to eat solid foods as well. And certainly he was also, I believe, seeing specialists, or there was talk of hypertension involved in here. But I mean, going back to elementary torts 101, you know, we're dealing with the eggshell plaintiff rule here, where this is not going to be something where causation is not going to come into play. And of course, while it's being argued that, to jump a little ahead, the causation instruction was faulty here, it was not. Both second-degree murder, both premeditated murder, which of course he was acquitted of and only found guilty of the second-degree murder, they say that his death was caused by the defendant. And this was argued extensively, I want to say from pages 973 to about 78 or so, wherever the closing argument happened for the defense, where they talked about why this is not in here. I think it would be, if this was in a 3850 context, I would argue that it is completely reasonable strategy to not put in the actual case law determining, intervening, or superseding independent facts, because of which you might want to rely on the jury's common sense. It might be better to talk to them that way. It is possible that that intervening act instruction might make the jury say, I don't believe this was an intervening act. This could have been the same as the common cold. I mean, the state actually might have been able to argue even more strongly of causation here in light of that instruction. And so I don't believe there was any reason that one would find counsel ineffective for not raising that. And further, under Steiger, I don't believe you can raise IAC claims, ineffective assistance of counsel claims, for the first time on appeal by just clothing them in fundamental error. I mean, this is quacking like a duck. It looks like a duck. It's a 3850 claim duck. This is not something where it's going to be brought up on fundamental error here, only if the trial court's failure to include this instruction amounts to fundamental error, which it doesn't, because this doesn't vitiate the trial. The defendant here is still allowed to assert causation as his defense, as was strenuously argued close to the end of the closing argument by defense counsel here. And then moving into, lastly, unless this court has questions on other points, just to address number one, the state, of course, understands Martinez and its progeny, but reasserts here that this is not rising to fundamental error. Extremely weak or weak, all that aside here, if I look at this case, it's not the sole defense. We had causation, we had accidental discharge. We also had, in fact, there was plenty of arguments during causation and when discussing self-defense in the shotgun of a lack of investigation. The shotgun wasn't looked at by law enforcement. The older paperwork from the specialist was not reviewed by the medical examiner. There was plenty here raised by the defense. This is not a primary case, and the state argues that it's weak. I understand that the defendant's group of friends that rode with him in the car argued that the victim here was the aggressor, and of course the state's witnesses here certainly argued the exact opposite. That does not put us in a situation where the defendant had a strong case or a case that can't be seen as extremely weak, because I would argue that the state then brought in a rebuttal witness as one of the other members of the car who certainly painted a different picture. There was, of course, some very inflammatory things being said or being alleged that the victim said during the defense's case in chief and being brought up on cross-examination of all the state's witnesses. And then you have a witness who was there saying that I don't recall it going down that way, who was along with the defendant in the vehicle when that night happened. And the jury issued about 3 questions here, one of which was saying they had a verdict. They had questions about spite, ill will, and the like when regarding the definition of second-degree murder, which is what he was found guilty of here. They did not have any questions necessarily addressing that forcible felony instruction. It is nestled in between the countless instructions that are involved with the stand your ground hearing. And it is possible that they are only looking at armed trespass in the event that he was actually within the house, due to the use of dwelling being defined right after the non-deadly version. And while, of course, Montgomery says armed trespass would never be appropriate here, it certainly could be, but the state, of course, understands that this was not independently charged as a separate felony. That being said, I imagine the defendant here would have argued that any aggravated assault or armed trespass happened because of independent of or was circular to this. And finally, the Florida Supreme Court has receded a bit. The Montgomery case came out, in 2010, discussing fundamental error in the vein of jury instructions, where excusable homicide and justifiable homicide were not given correctly as lessers. And of course, 9 years later in Knight, they've receded from that in stating that, if there is sufficient evidence to cover the primary offense or the offense that was actually found guilty of, it did not vitiate the trial. And those cases were, of course, receded from. I would argue that same thought process applies here. Taking the Florida Supreme Court's stance on fundamental error instructions, the fact the jury had no questions here, the fact that among almost 100 pages, if not over 100 pages of closing argument, this was not mentioned once by the state, and aggravated assault was only mentioned by the defense in terms of his own forcible felony that he was arguing that he was defending himself from. I cannot find one way, especially where there's accidental discharge causation issues regarding the global pandemic and lack of investigation. This is not a situation of other cases cited by the defendant. This is a situation that was expressly contemplated in Martinez, which is one that this particular instruction will not rise to fundamental error. But if this,
Counsel, how do we decide whether it's a weak, extremely weak, or so-so self-defense case?
well, certainly, Your Honor, if we had a situation where there was video footage or something of this particular incident going down, and then the state had no witnesses whatsoever, and the defense puts forward plenty of their own witnesses, but all that said they were there, but were people who weren't seen on the footage, I would easily look at that as extremely weak. Here, in terms of whether this is weak, extremely weak, I think if there's internal inconsistencies within the case in chief that come to a level that those internal consistencies make it almost inherently incredible to assert these particular situations, then I would argue that we're getting into extremely weak territory. But the state will also just clarify, extremely weak isn't an end-all be-all here. Even if this court found that perhaps this defense wasn't extremely weak, I still argue that it is absolutely weak. And taking all three parts of Martinez together, which is, was this the only defense? Was this a strong defense? And did the prosecutor focus on this in closing? We don't have focus here. This was not the only defense. And further, I don't find that this was a strong defense based on my assessment of the record.
I have one more question for you that Mr. Foreman can anticipate may come his way. How do we decide whether the verdict could have been reached without the erroneous instruction?
Well, Your Honor, I think that we need to look at, of course, the way that Martinez looks into this. It's the strength of the defense that I think is going to play in here. I mean, we have one group of witnesses saying things happened the way the defense says it did. We have another group saying the opposite. But of course, we have the defendant here going, we have plenty of witnesses here for the state stating that, you know, the defendant would, when he was shoved back, he proceeded to remove his firearm, say, I'm paraphrasing here, you don't know what you're messing with, I'm going to kill you. Meanwhile, on the defense's side, they're trying to say that we're reaching a level where unfortunate things were being said to this defendant, and at a point where he was being mobbed, and there was certain witnesses saying there was a shotgun in the back that it's possible the defendant couldn't even see based on the testimony. I think that looking at the credibility of both of these particular defenses, weighing those together, as well as looking at whether this particular jury instruction was focused on by the state, that's how I think we look at as whether or not this contributed. I think that if we would have a much harder case here, Your Honor, if the prosecutor below said, ladies and gentlemen of the jury, we don't have to do anything in this wide and vast amount of jury instructions detailing the stand your ground as a defense, whether who the initial aggressor was, because here we have him committing an armed trespass, or here he committed an aggravated battery. If you find he did either of those, he is not entitled to stand his ground. And maybe we get into the retreat instructions there. But if something like that was here, Your Honor, I think the state has a harder case. But that is not what happened here. The state argued within the parameters of the law in its case. And again, I think that looking at this evidence as a whole, looking at where this instruction pops up in the jury instructions, and looking as to whether or not this was a strong defense and whether or not it was focused by the state, that is how this court comes to whether or not this vitiated the trial. If this court has no other questions, I'll rely on the state's brief, and I ask that you affirm.
All right, thank you very much.
Thank you.
Mr. Foreman.
Yes, sir. Thank you. Before I address Your Honor's question, I'd like to just talk about a couple of points that the state made. In regard to Mr. McCoy, who is a state's rebuttal witness, he didn't say anything that was harmful against the defendant's case. And in fact, he said that Mr. Tatro, the victim, is the one who pushed Mr. Powell first, but he never saw the gun in the hands, and so he didn't see what happened because he dropped his cell phone. So his testimony only bolstered the defense case that Mr. Tatro was the initiator. As far as the state's argument about how some of the evolution of case law and somehow suggesting that Martinez is going to be overturned, I mean, I cited a plethora of cases in my brief, and there's even new cases coming out that I even cited that are granting new trials based on fundamental error. So to the extent the argument was made that maybe this isn't good law, I don't think that really holds much water. But I think it's very, very important to focus here on the armed trespass, because that's what makes this case different than all the other cases that involving this Martinez issue. And the definition, and the state in its brief argued like, hey, you know, if they didn't go into dwelling, the jury would have known not to, you know, apply this. But again, the trial was saturated with testimony and argument that the appellant was told to leave. On page 805 of closing argument, that's what the prosecutor hammering again, that he was told to leave and he didn't leave. Same thing on page 820 and 821 of the closing argument. The state made the same argument. But if we look at the jury instruction on page 700 of the record, it doesn't really talk much about the dwelling, to the extent that the jury would somehow limit this to whether or not they were going into the house. I mean, the instruction says Mr. Powell has been authorized, licensed, or invited to enter or remain in a dwelling. And there's testimony that he was invited by Jordan to enter the dwelling. But then it doesn't say he actually entered. It just says then he was warned to depart, refused to depart, and possessed a firearm. So maybe the jury certainly could have interpreted that as he refused to depart the area, which is what the uncontested testimony was. And the fact, essentially, once he drives up on that property and he's told to leave, he can never claim self-defense. And that's what's problematic in this case, which makes it different than all those other cases. We have that extra element of this non-forcible felony in addition to the other errors in this case. Now, going to Your Honor's question about, you know, how do we know that this, I believe you said, you know, affected the outcome, essentially. The defective instruction violated, it basically was a due process violation. And, you know, fundamental error has been found when there's been a due process violation. Here, the jury was denied the opportunity to consider self-defense by this jury instruction, especially in conjunction with the armed trespass. And again, we didn't have to prove that he acted in self-defense. The appellant just had to raise a doubt whether or not he acted in self-defense. And that's what's kind of being lost a little bit here. But again, this armed trespass is critical. And the language used in the self-defense instruction by the judge just uses the word armed trespass. It doesn't even mention dwelling. It says armed trespass on page 698. And then on page 699, it talks about armed trespass as well. And it's for both the deadly force and the non-deadly force. So I think that's a very critical distinction here. It's like saying basically once you walk into a store, you can't claim self-defense because you walked into the store. And that's exactly what we have here. And again, it wasn't an extremely weak self-defense claim. I recognize that the accident was a secondary claim, but it heavily and 100% relied on the claim of self-defense for brandishing the weapon. Otherwise, there's no defense if the state's case is believed once that weapon is brandished. And again, with the causation, without this jury instruction, it wasn't even a strong argument because, you know, it would have allowed the defense to talk about an independent act, talk about COVID. You know, independent intervening acts aren't defined. So it would have allowed defense counsel to strengthen that causation. So self-defense was clearly primary. It was not extremely weak. And the inclusion of this armed trespass negated anything that happened once he was told to leave and he was possessing that firearm. And if there's no question, like I said, I'll rest on my brief, and I respectfully ask the court to grant a new trial for all counts.
All right, thank you very much. Very interesting case. We'll be in recess.
Thank you.